Good day and welcome to another edition of Q&A Social Security Disability Today. I'm your host, Attorney Anthony Reeves, so let's go ahead and get to your questions. First question is, why does it seem that I'm always getting the same paperwork from Social Security? Okay, there may be a couple of reasons why you're getting duplicative paperwork, but let me tell you the more important reason why you're getting duplicative paperwork. Consistency. Here's why I want you to understand. At various parts of the Social Security process, whether it be your initial application or even your request for reconsideration, and sometimes at the hearing level, Social Security may ask you to provide them updated information by the use of various forms. A lot of times, people don't realize that the information in the forms really is just asking you usually for updates. So they may say, have you worked since this date? Have you gone to a doctor since the last time we've seen you? Tell us who you've gone to see then. So a lot of times people will see those forms and think, man, didn't I just give you this information? Here's what I tell people all the time. Social Security is looking for consistency in the information you're providing to them. So if you find that you're getting paperwork that you swore you've completed before, there is a good chance that you may have received that information already. Don't get mad, don't get frustrated, just complete the form, provide it back to Social Security, and just be aware of the responses that you previously provide. When in doubt, if you filled out the form already, keep a copy for yourself. So if it looks like they're asking you for the exact same thing again, at least you'll have an idea of what you put the last time, and you're not trying to remember what you put. Alright, our second question is, how effective would it be to provide copies of police reports in supporting a claim of mental disability to the Social Security Administration? Here's what you got to keep in mind. That Social Security takes in consideration not only medical evidence, but other evidence to demonstrate that you are disabled. So here's the kicker that you have to ask yourself. One, is providing reports from police going to be helpful? It just depends on what the report has to say. For instance, if there's something in the report that gives an indication that the reason you may have been arrested is because of your mental impairments, meaning not necessarily they arrest you because of your mental impairments, but maybe there are statements made by the police officer that are consistent with statements that have been made to your doctors about erratic behavior, violent temper, things of that nature, it might be helpful. However, I don't want you to think in your mind that just because a person is schizophrenic or psychotic disorder or they have a mental impairment and then they get arrested that the two are naturally connected, because Social Security is going to want to know, how are you connecting the two? And you just can't make the assumption that just because you got arrested, or even if you got arrested for some type of violent action, that automatically is attributed to the mental health condition. The key thing is, how can you use that evidence to demonstrate that there is a connection to your mental impairment or to your Social Security claim? In other words, you've got to be able to show that one is connected to the other. Just because one happens does not necessarily mean it has a direct correlation to the other. So keep that in mind. Alright, our third question is, what effect would a mental residual functional capacity form completed by a treating psychiatrist do on your Social Security case? And you know what? This is a great time for me to talk about RFCs. Here's what I tell people. Under most jurisdiction, every jurisdiction, meaning federal jurisdiction, has a variation of the treating doctor rule, which is basically an extension from the federal regulations. Here's what the rule basically says. Your treating doctor's opinion will be given considerable weight if supported by the weight of the medical evidence. In other words, if a doctor who's been treating you, maybe in this case a treating psychiatrist, completes a form on your behalf, and the weight of the evidence in the file, meaning both evidence that they provide medically and as well as other medical providers, supports that doctor, then that report can be given very substantial weight. Here's where it gets a little tricky. If by some reason your doctor writes a report to you and it's not supported by the weight of the evidence, it's going to be given little weight. Now, I know some of you are like, you're using all this weight term. What do you mean, Mr. Reeves? Here's what I mean. Let's say that your psychiatrist writes an RFC, and the which we call the residual functional capacity evaluation, and the RFC basically says that you have marked abilities, meaning you have a hard time focusing, concentrating, hard time working with supervisors, doing simple work, hard time working with employees or the general public. You look at that form and it's awesome. However, when they go into the medical records for you, it looks like the only thing you're taking is Prozac. The doctor's notes appears to show that you have mild limitations, and then other doctors that you've gone to before also indicate you have mild limitations. Guess what that means? Well, it means that a lot of the medical evidence that I've just mentioned shows that you don't have severe problems, meaning they're problems but not so severe to keep you from working. Yet the form says you have severe problems. So that's what we call an inconsistency, meaning the report says you're off the chain, but the medical record says you're not. So that would mean Social Security more than likely is going to look at all that medical evidence and say, you know what, looking at this evidence as a whole, I don't know if I'm going to say that that report is as helpful to you because your medical records show that you may be having problems, but not to the extent of this report. So the short answer, or long answer, as a long-winded attorney I am, to your question is really this. The report is only as good as the medical records that can support it. So the key question is not so much the form, which is always helpful because it tells Social Security what your limitations are, but not only is it the report helpful, but you need to also know, are the medical records going to support what that form says? Fourth question has to deal with the fact of what happens if somebody is 28 years old applying for Social Security disability benefits. Okay. Really, the focus of this question is, what impact does being young have on applying for Social Security disability? Part of this is going to be a little bit of my own kind of soapbox, so please kind of indulge me for a second. Here's one of the things that I tell people. The regulations get more favorable as you head into different age brackets, meaning the hardest level to show that you're disabled is the children's level, because children are resilient and they're tough and they can deal with a lot of stuff, so Social Security does not like to say that a child is disabled. That's anything from day 1 of birth through age 17. When you turn 18, you become an adult. 18 to 49 is considered a younger individual under the regulations. The reality is that Social Security system pretty much works self-sufficiently on its own when you're paying into the system. And I'll be honest, and this is one of the things that I tell people when I have young people come to me. I always say, I want you to be cautious of the fact that the regulations are not as user-friendly when you're young. Why? Well, one, you're young, meaning there is this thought that you may have the time and the ability to move into other areas of work that maybe if you can't do what you used to do, it's going to be a lot easier to move you into arenas where you can do other things. Also, it's not just youth by itself. We have to look at everything else. We have to look at your work background. We have to look at your education level. But I always tell people that the regulations tends to not be favorable to young people because ultimately the young people are the bread and butter of the Social Security system in terms of working and paying into the system. Now, am I saying that if you're young you shouldn't apply? No, I'm not. I'm just saying that when you're applying, keep in mind that when you're younger, Social Security, they're not going to penalize you for being young. It's just the regulations when looking at you as a whole, it's a lot of times Social Security is going to have the presumption that you are probably in the best position to be able to reintegrate yourself into a new job. So just keep that in the back of your mind. Okay, fifth question. Can the Social Security garnish my Social Security disability benefits because I defaulted on a Small Business Administration loan? Here's what I tell all people all the time. First of all, if you're talking about the Small Business Administration, I'm assuming you're talking about federal, not your local state. If it's your state, they probably are not going to be able to garnish. If it's federal, there's a pretty good chance that they will be able to. Let me tell you why. Social Security, Congress, in their brilliance, and this is what I applaud them, created what they call the anti-garnishment statute, which basically prohibits certain individuals from being able to garnish a person's Social Security disability benefits. So a lot of debt that you may have acquired over the course of your time period cannot be garnished from your Social Security benefits. However, Social Security Administration has left the window open for a few exceptions. One is child support, another is alimony, and then the third, which is the one that I tell people gets people a lot of times, are federal debts. Well, what do I consider a federal debt? It can be anything. We're talking you owe the IRS money, student loans, other Social Security programs where you owe money for that one. And I always tell people it could be additional loans out there that you got through the federal government. Remember, Social Security is a federal program. So guess what? It is very likely that if you owe money on a federal debt, they may garnish your money as a result of your responsibility to that federal debt. So I always tell people that there is that possibility. Contact your Social Security Administration office, and they'll tell you. And just say flat, I've defaulted on a loan with the SBA. Is that going to be garnished? And they can tell you how much it is and if it is. Now, for those of you out there who want to run dirty and not say nothing and say, oh, I don't want to tell them because I don't want them to garnish my money, I got news for you. If it's a federal debt, they will know. So don't front and think that you're hiding anything. They're going to find out. So it's always best to your advantage to bring it to their attention first, so that this way you can possibly see about doing something to work it down, or maybe see if there's ways you can get the amount per month brought down so it doesn't hit you too hard. But please keep that in mind, because I don't want anybody around here thinking that they can duck from the federal government when you owe a federal debt. All right, number 6 and our last question of the day. What do you do when you lose your benefits after several years? The judge, and this one is a fact pattern specific. The judge says the state failed to prove that they were disabled. The result reinstated 28 months ago, $58,000 retroactively owed. All right. This sounds like what we call a CDR case, what we call a continuing disability review or a cessation case. Let me tell you how cessation cases play out so that you understand how this works. You are on disability benefits. Out of nowhere, you get a letter from Social Security telling you that they don't think you're disabled anymore. You go in and you contest because you believe you are disabled. So guess what you do? You tell Social Security that you want your benefits to continue while you fight it out. Well, even though you know this, they tell you that as a result of you asking for it to continue, if you lose, you're going to have to pay this money back. So then what happens is you fight, you get appealed, you get the appeal there, you lose that appeal, you go before a judge. It's usually probably about a year or so later, now heading to about a year and a half, maybe 2 years, and you finally lose before a judge. Guess what? You got to give all that money back. Not a whole lot you can do about it. You can maybe ask for a waiver, maybe ask for a reduction, whatever the case may be, but you have consciously told Social Security that you want your benefits to continue. Now, under that scenario, there's not a whole lot you can do. Where you've told Social Security you want your benefits to continue, that's one thing. The other thing is where Social Security continues to pay benefits, but there was an error made on their part and you shouldn't have got the money in the first place. There might be that's a lot different. Under that scenario, you may want to ask for a waiver, i.e. you telling Social Security that the reason why you should not have to pay that money back is because it wasn't your fault. They told you were disabled, they screwed up, and they just caught it recently, so you shouldn't be penalized because of the fact that they just found out about it now. There was no way for you to know that. So it really just depends on the circumstances involved. The question that was provided to me, those were the limited facts provided, so I don't know if this was one where they would apply for Social Security, got Social Security determined that they were no longer disabled, and then the person asked to keep it going. That on the first scenario, you owe the money, you're going to have to pay that money back, period. Under the second scenario, where they awarded you benefits and it was a mistake on their part, you're going to owe that money back, but you have a good grounds to fight it. And I always tell people this: you can fight anything all the time. The reality is that it really just depends on how strong the facts in your case are with regards to whether or not you have grounds to prevail. If you have a question, please feel free to leave a comment or message with your question on the Reeves Law Firm YouTube site, www.youtube.com/Reeves Law Firm. If you would like to chat with Anthony Reeves live, visit the Social Security blog, legalbeat.anthonyreeves.com. For a full view of all of the Reeves Law Firm resources, visit www.readfirm.com. Resources are there for you. All you need to do is ask. All right, everyone. I want to thank you again for tuning in for another edition of Q&A Social Security Disability Today. Keep those questions coming, and as always, have a wonderful day, and I am glad I was able to provide you your Q&A Social Security Disability Today.